Okay, we're good.
Great. All right, good afternoon, everyone. My apologies for the delay in getting started. Thanks for joining us this afternoon. I'm joined by a number of our members of our Aboriginal Rights and Research Office, as well as our legal counsel. Today, we're hosting a Zoom session, as well as being streamed live on our MCA Facebook page. This afternoon's session is a continuation of the education campaigns that we've been having around the proposed Seaway settlement. So as you may have heard, we have a referendum that is ongoing as we speak. The Mohawk Council of Akwesasne has received an offer from the Government of Canada to settle what we consider the Seaway Claim for $45 million. And today, we're here to share more information about what that settlement means, a bit of history on the claim itself, which has been was started as a lawsuit against Canada several years ago, and has made its way through some of a court process over the last several decades, has been in the court. And most recently, before COVID, an offer had been made to our community of Akwesasne to settle the claim in its entirety for a nominal amount of $45 million, including the return of some lands on Gawanoge and bringing the claim to a resolve. So we want to share information with you, ask questions that the community may have, share information about the actual referendum that's happening now and in the upcoming in-person voting that will be taking place, as well as sharing some information on our next information session that we have scheduled for next week to present to the community again. We have had three thus far. I do want to acknowledge the hard work of our Aboriginal Rights and Research team, who has been on the ground educating the community about the claim itself, talking about where it started, where we are now, and what the settlement offer means to the community in closing out this file. We're also joined by legal counsel Nathan Richards, who has been also attending those sessions as well, answering some of the legalese questions that community may have, talking about what the settlement means, as well as in relation to ongoing or what is covered in the claim and what is not covered in the claim, and what that means to our community. So as you know, the Seaway itself was constructed in the late 1950s into the 60s, where we've seen the Seaway was dredged. Millions of metric tons of our lands, predominantly on Cornwall Island, was excavated to make way for the shipping channel itself. At the same time, lands were expropriated. That includes the highway corridor, which we consider from Cornwall Island to Roosevelt Town. The construction of two bridges happened at that time as well, including the placement of customs located around those bridges. As well, during that era, the hydro dam, the OPG hydro dam, the Robert Moses Dam, was created then and was constructed as well and became operational several years later. Now, that is an element that is part of the initial overall impacts of our community. You may recall that our community settled in the late around 2008, 9, the OPG claim, and that we settled with Ontario Power Generation for the damages created by the flooding and the hydro dam itself. So the Seaway claim itself initially covered part of that. We hived off part of that when the community accepted the damages created by the hydro dam. And now what we have left is the damages that have been created by the shipping channel, including the highway corridors, the expropriation of lands, and the taking of the lands on Cornwall Island. So that's a real quick summary of where we're at. I'm going to turn to Cheyenne with our Aboriginal Rights and Research Office. Was there anything that you wanted to give a highlight on? I think I've done a pretty good job in explaining, in a few moments what the background is. I'll turn it to you. You're on mute.
Okay, sorry. So I'd just like to point out that the information presented here today is for the sole purpose of educating the members of the Mohawk Council of Akwesasne on the history and the proposed settlement of the Seaway Claim. The information contained is without prejudice to any and all past, future, and current claims of the Mohawks of Akwesasne. I do have a PowerPoint I'm going to share. Can everybody see that? Okay. So Grand Chief went through this. So in the Seaway Claim settlement offer is between the remaining parties, which started in 2015, and in 2017, the proposed current settlement agreement, MCA approved the draft in 2018 and ordered a community referendum in 2023. Canada's offer is for $45 million in compensation and for the acknowledge and the return of 4 islands and lands located on the Governor Reserve status through the ATR process. So the Block 1 lands have already been returned. In the current settlement agreement, the surplus bridge corridor lands were added, as well as the guarantee of the return of the Western Islands and a portion of Stanley Island. It also ends any grievances of Akwesasne against Canada regarding the Seaway Claim. The 4 Western Islands, Sheik, Presqu'île, Tucson, and Adams are currently in the ATR process and were included as well in the OPG settlement agreement. Negotiations for the Seaway Claim settlement agreement are complete, and the Seaway Claim settlement agreement document was shared with all members. If you don't have a copy of the settlement agreement, you can always come to the Aboriginal Rights and Research Office. We are located at Admin 1 in Ganadago for a copy, but they were mailed to all homes. Online voting began Friday, August 11th at 9 a.m. and it closes August 25th at 5 p.m. with in-person voting starting August 26th from 9 a.m. to 5 p.m. in the district of Gowanoga at the Recreation Center, the district of Desnaina at the Recreation Center, in the district of Ganadago at the Ganadago School, and in the southern portion of Akwesasne at the St. Regis Mohawk Tribe Office of the Aging, located near Generations Park. MCA will not enter into a settlement agreement unless it has been approved by the membership of the Mohawks of Akwesasne. The voting threshold is a simple majority of the eligible membership, 18+, and voting eligibility is all members of the Mohawk of Akwesasne under the Akwesasne membership code, regardless of their place of residence. You need to be 18 years of age on and before August 1st, 2023, and you can verify your membership status at the Office of Voter Statistics. If there's a yes vote, it means if you're voting yes, you mean you accept Canada's offer of $45 million in compensation, the ATR process for the Block 1 lands, which have already been returned, the surplus bridge corridor lands, a portion of Stanley Island, and the 4 Western Islands, which are currently in the ATR process. It ends a 47-year-old grievance. Voting no means you reject Canada's offer, and there are options. One option would be to renegotiation between the 2 parties to find a different settlement terms. Federal court, which has no guarantee of a win or a greater amount, and a specific claims tribunal, which has a $150 million cap, no guarantee of lands or a greater amount, and can be easily appealed. If you have any questions, our legal counsel is Nathan Richards, who will be going through the settlement agreement with you, and he's currently here. Grand Chief, District Chiefs, Community Education, you can contact myself, Teresa Benedict, Adam Jacobs, or Sheila Oakes at arrow@akwesasne.ca. And any questions regarding the referendum and voting, you can contact Chief Referendum Officer Leona Benedict.
Okay, thank you, Cheyenne, for that. So today's session, we have all of this information is online at akwesasne.ca under the Seaway Claim tab. You can either Google Akwesasne Seaway Claim. The PowerPoint will, we can load that up. It's not on there, but what is on there is the documents that Cheyenne has referenced, the actual agreement that will be signed if accepted by the community. We have what we call a plain language as well as on there. So the agreement itself is a bit legalese, has some language in it that we would find in a legal document. But what we have done is put a side by side on that one in more general terms of what that language says or what that agreement says. So that is available on our website as well, that we're sharing with you. So I know that one of the questions has been about, what's going to happen with the funds. Like, it's $45 million. I acknowledge that we do have a claim that was settled previously, which we know as the Dundee claim, and some resources were found from that as well. I know that community has been asking what's going to happen with this money. So I can tell you that in relation to the Dundee fund, it has taken some time. I want to acknowledge that, we spent 2 years in COVID. Initially, when this settlement was made to Akwesasne for consideration, we were going through the appeal process of the Dundee claim. And what the process is that we, once the Dundee either was going to be settled and the appeals were going to be dismissed, or we could have been going back to another referendum based on the appeals. So we didn't take this Seaway claim to the community when we initially right away when we got the settlement, because of because of the Dundee claim was still an appeal. So once the Dundee claim was finalized, we were heading towards having a referendum for the Seaway claim, and we received this in before COVID. And what happened was that COVID struck, and we spent 2 years in COVID and not being able to bring this to the community. So now that COVID is over, we've been moving forward with a consultation on the Dundee of what to use those proceeds were, and also the education and this referendum that we're moving towards with relation to the Seaway. Now, there is a big element that we've been questioned about, and that's around the impacts of erosion has had on our community. And I can tell you that one of the things that we will be doing with the proceeds, identifying some monies to mitigate the erosion effects around the community. Now, we have had extensive reports done on what the erosion factors are through the entire community with respect to community lands. Now, acknowledging that this settlement does cover some of that erosion with relation to the operation of the shipping channel. Now, there are other places where there's erosion occurring that may not be impacted by a shipping channel, but perhaps could be impacted by our own recreational boating. I know that there's some areas in that. So what we want to do is identify funding so that we can begin a mitigation process to stop the erosion that's happening throughout the territory. Now, you can imagine that this requires lots of planning, requires some assessments and what have you, but also the capacity to do this. So I know that this is a big question that has been brought up, what's going to happen with that and how we're going to address some of the issues that are impacted by it. The other issues that are included, or the other things that are wrapped up included in here as well, is the ongoing continued maintenance and operation of the corridor, what they consider the corridor, that's the toll plaza. There is some language that's included in the settlement agreement that says, should the federal government ever wish to sell or get out of the business of operating the toll or perhaps the bridge, that the Mohawk Council or the community of Akwesasne would be given consideration. Now, I think this is extremely important when we look at community and business development, because there are some operations that I would say that happen within the corridor between the bridge from Cornwall and bridge to Roosevelt Town or Messina, i.e. snow plow, snow removal, and perhaps some of the smaller maintenance stuff. If the Seaway National Bridge were to ever look at privatizing or putting any of these services out for tender, there's language in there that says that the Mohawk Council will be given either preference or will be working closely with the federal government on that. So that's, that's included in there as well. I know that we've had lots of discussions around, the toll plaza and the impacts to the community. So one of the things that's included as well in the settlement, if accepted by the community, is the shrinking of the corridor. So as you know, we consider the corridor from between the two bridges. There's a lot of green space in that area. That was part of the original expropriation for the creation of the highway or the corridor between there and the roadway. That footprint will be shrunken down on both sides, predominantly around the American Bridge, and then up around where the actual toll used to be, or their offices, administrative offices. Those buildings and that land there will be returned. Will be turned over to our community as well through after the agreement is, if the agreement is accepted, and they will build new facilities over near Canada Customs. And then once those facilities are completed, they will vacate Cornwall Island. Those lands and buildings will be turned over to the community, and we'll undertake a process at that time to identify either best use or if it's going to be removed. That's built. That's part of the planning that we need to do as a community as well. With respect to the toll booth itself, we have been, there's two things happening on the toll booth side. We have been in conversations with CBSA and the toll to look at relocating the toll plaza behind Canada Customs, because as it is now, you go through toll first and then you go through CBSA. If the settlement is accepted, that definitely will happen. If the settlement is not accepted, there's still the opportunity. We are still in conversations to have that done. But what the settlement will see is that there's monies available for the relocation of the toll to be behind CBSA, which alleviates some of the traffic issues that we have. But as well, looking to do some tolling one way as well, so that we can return back to Cornwall Island without having to go through a toll plaza. That's some of the conceptual that's in there, but that language isn't covered in this agreement as well, to provide resources for the relocation of the toll and the administrative buildings that exist on Cornwall Island. So I've done a lot of talking, and I'll stop there. Nathan, I know that you're here online with us as well. Is there anything that you wanted to add, or maybe some questions that you recall from the community sessions? I know that you were at the last three. I do want to apologize to the community for not being available. Unfortunately, my schedule has been very hectic, and I was out of the community during that week that these sessions were occurring, but I am joining today and will be available next week as well, available at any time to discuss these matters. So Nathan, I'm going to go to you for some comments or anything that you wanted to add.
Thank you. Just let me know if you have any trouble hearing me. All right, so I think that was a pretty good summary of the claim, as well as what we're doing here. And essentially, what we have on the table in front of us is a settlement agreement which would settle the claim. And the nature of this settlement agreement is to provide a description of that claim, of the Seaway claim, within the document itself, to provide some remedies for the claim and for the grievances of the Mohawks of Akwesasne, and then to extinguish the claim itself. Okay, and so that's basically what this document does in very, very brief terms. And if you want to go through the settlement itself, then you can find the definition of the claim at section 1.1.
You didn't even stop, fucker.
Sorry about that. I don't understand what they said, but go ahead. Okay.
1.1L of the Seaway claim, and you can have a look at that definition on your own. It's quite a lengthy definition, but the basic thing about this claim is that it relates to the construction, operation, and maintenance of the St. Lawrence Seaway and the highway and the bridge facilities that cross Gawanoge. So that is the core of the claim, and the description of Seaway claim provides some different aspects of that, and you can go through that in section 1.1. So that's the first thing that this settlement agreement does, is it sets out what the claim is in fairly detailed terms. The second thing is it provides you, as the Grand Chief said, and as Cheyenne said, it provides you with some kind of a remedy to the claim, and that remedy is the $45 million in compensation, a settlement, as well as some other, basically a return of lands, particularly in the corridor, and some lands as well on Stanley Island and the Western Islands. So that's the remedy. And then the release is there, and basically the release, you can find the release in there. It's at section 7.1, and once again, the release is fairly detailed. You would have to go into the settlement agreement itself, have a look at 7.1 and then 7.11. But the main thing that it is releasing is all of the claims for damage that arise from the construction, operation, and maintenance of the Seaway Channel. When I say the Seaway Channel, I mean just the navigation channel itself and the bridge. All right, and so that's the basic nature of this agreement, is to describe the claim, describe the remedy, and to release the claim. So that's just really overview. Now let me just go to some of the questions that I've had over the last few sessions, and some details that you should really be aware of. The first thing is, the release is only about damages that have happened up till now, and certain damages that may happen in the future, but they all are connected with the navigation channel, the construction, operation, and maintenance of the channel and the bridge. They're not connected with other issues you have. And so there are limitations on this release. It is not an everything release, and it doesn't give any consent to the future construction or modification of the navigation channel, or the bridge. So I think we've all understood by now that maybe one day they're going to put a second bridge across the South Channel there. They may propose at some point change to the Seaway, the navigation channel itself. You haven't given them any consent to that. You can oppose that in the future. This agreement cannot be held against you with respect to that. And so you have a free hand to oppose and to negotiate with respect to any future works, right? And that was a really important exclusion from the scope of the release. Obviously, as well, you're not giving any kind of surrender of rights or title to lands anywhere in Akwesasne. This is not a surrender of any kind. It will involve a discontinuance, which means you won't pursue the actual monetary claim in the federal court, but all of your Aboriginal rights and Aboriginal title and your treaty rights are expressly excluded here. And so I'm just going to read that to you. It says, nothing in this settlement agreement shall affect or be deemed to affect any right of the Mohawks of Akwesasne that is recognized and affirmed by Section 35 of the Constitution Act 1982, including the right to obtain a declaration of such rights in relation to matters outside the Seaway Claim. And so not only are your constitutional rights preserved in this and unaffected, but those rights are also the procedural right to obtain a declaration of them in the court is specifically protected. And the release also doesn't include any of your rights that arose under the Indian Act in the 1950s, or under any of the documents or orders in council that were issued by the government of Canada in the 1950s. And you actually do have some significant rights under those orders in council still to this day, which are essential to preserve. And so 7.2.3 of the agreement preserves all of those as well. And so basically, this is a release, a description and a release of claims with respect to damages that occurred. And most of those damages, quite frankly, occurred on Gawanoge. A number of islands were affected. As the Grand Chief said, erosion was a real driving issue here. And there were significant damages on Gawanogi itself to parts of the island, including that part called Area M and so on and so forth. So those have been the drivers of both the compensation claim and the settlement. So those are the basic parameters. I don't know if there's any questions coming in. If so, I can take a question. If not, I'm gonna talk about the money. No questions? All right. I think that one of the main questions that people have been asking over the last 3 information sessions is, what do I compare $45 million to? What is the value of 45 million compared to what we might get in the settlement, in the proceedings if they proceed to court? All right, that's a pretty fundamental question that has come back several times. And in order to answer that question, I compare the $45 million that is offered to my expectation, and here I'm speaking as your lawyer completely from my professional point of view. I'm not speaking from the Grand Chief's point of view or Cheyenne Lazor's point of view. This is my advice as a lawyer, as I'm required to give you. And so I compare the 45 million to what I expect will happen if this matter proceeds in court, in the federal court. Okay, and I don't. The basic sense of what would happen is, what I do is I look at the provable compensation, and I look at the evidence that we actually have at this time to prove certain amounts of compensation. I look at the probability of success. So I look at how likely it is that a court is going to declare Canada liable to pay certain amounts of money. And then I also look at the cost of continuing these proceedings. And so I put my own number values on certain aspects of your claim in court. And this is my own subjective estimate of what your claim would be worth. And so basically, just to line it up for you, the compensation was agreed in 2018. It is $45 million. In 2016, we had provable damages caused by ship-generated waves in the vicinity of $20,410,000. So that is a figure that is found in an expert report that we have that would contribute to the proof that we would make in court about the erosion issue. We have a second expert report about the cost of remediation of Area M, and that one provided and this is once again 2016 dollars, provided a figure of $2,254,226. So about $2.25 million for in damages for Area M. Area M is an area on Gawanogi where they dumped an enormous volume of soil and causing considerable damage to the actual land itself. So that is what the expert came back on that score with. We have another expert report. I only can give you basically an average of the amount of compensation in that expert report because the methodology, found different amounts for different scenarios. But according to that expert report, the provable damages are around $5 million with respect to the loss of revenues from the bridge corridor from the 1950s, late 1950s, early 1960s to the present day. We have a very substantial range of what I call unquantified damages. Unquantified damages are damages that we know occurred, but we are unable to quantify because the evidence is insufficient. And so there's a fair amount of unquantified damages at this time. And then up until this time, and I'm still here in 2016 dollars, the cost of the claim has been about $3.75 million to that time. And so when you do the weighing analysis here and you look at that $45 million compensation claim, you're basically stacking that $45 million, or I am stacking that $45 million up against a total of about $30 million in claims. And there's some unquantifiable damage in there, $30 million that we are in a position at this time to prove in the federal court, minus the amount of costs. And so in that sense, the compensation itself, it substantially exceeds what the expectation is. Now, that's what I call provable damages. The next thing that you have to consider is your chances of success in obtaining an order from the federal court, saying that the Crown is liable for certain harms that came about because of the construction, operation and maintenance of the seaway and the bridge, and therefore an order saying that Canada must compensate the Mohawks of Akwesasne. And the chances of success with respect to erosion are strong. I think that we all feel that there's a fairly good case for erosion because we had such an excellent expert report, which fairly clearly established a cause and effect relationship between the ship generated waves and the erosion. So that's a strong claim. The evidence of damage in Area M is strong as well. The evidence of the cost of remediation is fairly good. I wouldn't say it's as strong as the erosion claim, but it's a good claim. It's something that we can definitely work with in court if we go that direction. And so the chances of success on that one as well are good. I said that there was an average of $5 million with respect to loss of revenue for the construction of the bridge. That is the actual estimation is quite solid, and it can be used in court. The problem with that claim is that the likelihood of the court actually finding that the Crown was required to provide a revenue stream is not that good. So the chance of establishing the defendant liability is probably less than 50%, but it's sufficiently strong to go somewhere. And then the other damages, there is certainly some evidence of losses. The real problem with a number of the damages identified or claimed is that the evidence doesn't take us to the point where they can be quantified. And when the court is faced with unquantified damages, it basically the court just has to do its best to find an appropriate figure. And generally, when a court is faced with relatively little evidence, the tendency will be not to be overly generous or in terms of making an order. That the orders tend to be conservative when we're talking about unquantified damages. And so
Nathan, we have a question about that before you move on that. So
okay,
from the unquantifiable damages, would this settlement close the door on taking that to court if they become quantifiable at a later date?
Yes, absolutely. If they are, if those damages are reasonably said to be caused by the construction, operation, and maintenance of this navigation channel, then they will be released, whether they are quantified at this time or not. And you will not be able to go back in the future with respect to those damages. So that is a straight answer to that question.
So if they become quantifiable later, you're not.
Yeah, I mean, the real, I think the underlying question is, what is the likelihood that they'll become unquantifiable? Damages don't become more quantifiable with time. They tend to become less quantifiable with time, right? Because things fall apart, basically. Slowly, it becomes more and more difficult to make evidence because folks die, situations change, like other factors start to affect the issue. And so a lot of these things, one of the reasons why they're unquantifiable now is because they happened in the 1950s and 60s. And we're just no longer at that place where we can bring people forward and say, look, these are the specific damages. And so the sense, there is no sense in my mind that a lot of these damages are going to become more quantifiable. In fact, they seem to be going in the opposite direction.
Okay, thank you. Okay. So we're going to pause there. We're only scheduled till 1 o'clock, unfortunately, for availability, but we're gonna turn to any of the participants online. I know there was the question that was typed in the chat. I've asked that of Nathan, but if there are any other questions, we will take those as well before I asked Nathan to move on. Okay. All right, Nathan, I know I cut you off before while you were talking about that, so.
So we were improvable compensation, and basically, you know, the message to the folks in Akwesasne is that if you compare this compensation offer to what you're likely to get in court, it's an attractive offer. If you compare it to other things, well, it may seem less attractive. It really is a question of what you want to compare it to. And because I'm a lawyer, and because the fundamental issue for me is either it goes in court or doesn't go in court, I compare it to what the outcome is in court. And I'm quite willing to say that the expected value in court is not zero. I do expect that if you go to court, that you will have some success on various aspects of the claim, right? It's not a slam dunk. Your claim is not a slam dunk by any stretch of the imagination, but there are some strong points in it. There are some weak points in it. It's always, every claim of this size comes back with some surprise. Right? Nobody who goes through a claim like this, which has taken literally more than 40 years to get to trial, can predict completely the outcome. And I can't. But I expect that you would get something in court, but you would get less than you will be getting if you accept this offer. And so that's the basic thing that I take away. It's worth understanding as well that the settlement agreement was initialed in 2018, and we have been in a period of inflation. And basically, if this settlement is not accepted, or if it is accepted, well, you'll get that amount of money as it is. It's a 2018 amount of money. It will continue to erode if you don't accept it. And so there's been a very substantial amount of inflation, and the inflation is something that should either incite you to move forward and get a final decision on this, or consider other options. And so you have to take that into account. The total between 2018 and 2022 is 17.7% at the moment, and most of that is in the last 2 years. With incredible rises in the price of gasoline and food. And so there has been a real inflation situation out there, and this agreement is not inflation proof by any means. So that's an important consideration. If you do go to trial, the bottom line is that you have most of what you need in certain respects to go to trial now. You have a certain number of expert reports. As far as I know, those experts are all still capable of working with you, so that's a good thing. You could take those expert reports to trial. You would need to do some further work. Back in 2015, I had considered it would take about $1 million to get to trial, but I doubled that today now easily, because there are things that have to be, basically picked up and done over again, or at least brought up to date, because there's been a fair amount of time that's passed since the main bulk of the work on the trial was done in 2015. So I'd say your cost of getting this to trial could easily be $2 million, and that's spending over several years. And then the trial itself is another $2 million. And so when you look at that, you're not likely to get, I mean, if you do succeed in this claim, you would probably get an award of costs in the federal court, but it won't come near to the amount of money that you have actually spent, because costs in the federal court just do not rise up to the amount that parties spend on their lawyers. It's just a simple thing, and unfortunate perhaps. And so you could get some back, but if you were to get an award, let's say of $30 million, which I would consider to be a fairly decent award in the federal court for the claims that you have, then you would still have to take off or assume that would include about $3 to $4 million at least in legal costs you've sunk into this matter. And so that's what it looks like at this time. Those are
there is something that I wanted to add. So I was one of the lead negotiators on bringing this claim to a proposed settlement that we have today. And I can tell you that over the last several years, the Mohawk Council of Akwesasne has budgeted significant amount of monies annually to support the claim, the Seaway Claim litigation, meaning going to court. And I think that while Nathan has said it's probably around $3 to $3.5 million, we as the MCA has probably put in at least another $500,000 to $1 million of our own time and energy into this case as well. I can tell you that the Aboriginal Rights and Research has supported Nathan in a number of ways in research. There has been interviews that had been previously done. So there's a lot of energy that has gone into this. So, we're probably capping out around $4 million that has cost us. Nathan has described what it would be going forward. This was one of the driving factors, two things, that this was really old. We want to bring this to resolve. Like this was, the lawsuit was launched, in the late 60s, early 70s. The damages happened in the 50s. But it's also, a long-standing file to the community, but also putting some significant financial resources into it. And I think it's important to understand that, predominantly this claim is for damages, which means that, it's for what was done to our people. Acknowledging that some of the lands were taken, there are the Block 1 lands which have been returned. The only lands that are left is the highway corridor, and the other lands had been expropriated. So again, this is predominantly a damage claim, which means everything that has happened to our community, that has happened to the lands. There's a settlement being proposed to bring that to a finality. Now, and Nathan has given a lot of description on, if we go to court, what does that mean? Definitely, this is why this is being put to the community. If the community feels that the $45 million plus the return of some lands on Cornwall Island, the shrinking, some language in there that says that if the operations of the toll plaza and the bridges were to be sold or third party, there would be, the MCA would have a preference on moving that forward, become either a provider or an owner, which is not impossible. Those sort of initiatives, including the relocation of the plazas the administration buildings, the Seaway National Bridge buildings off of Cornwall Island, these things would not come from going to court. The court would order financial damages, and that's it. So that's one of the things that we have to consider, our risk. And I can tell you that if we do hit the court, this will take several years. The court's very slow. We'll have a significant investment being made, and at the end of the day, we're not sure what we could get, if anything at all. But ultimately, it's up to the community. I believe that this is a fair offer. It's it will bring a finality to this, acknowledging, which is important as well. I could tell you that in some of the circles that I have been in with other, with either the Government Canada or Environment Canada or some municipalities around that run along the Seaway, there have been conversations about either deepening or widening the Seaway. This is not new. We have we've received documentation several years ago about that. And what I can tell you that is, if this claim is accepted and the government then decides they want to deepen the Seaway, those damages are definitely not included in this. So any new damages in relation to new construction, deepening, widening of the shipping channel we can be back at the table again, either suing them or requiring, compensation for damages to our community. And I can tell you that the environmental protection laws in the 1950s and the 60s are completely different than they are today, as well as the duty to consult. So if the federal government is looking to make improvements with respect to the Seaway, the shipping channel, including the replacement of new bridge, these the obligations to consult are completely different than they were in the 1960s. And this claim, is really about the collective damages done to the community at that time. So I do see that there's some questions that we have here. Question from Facebook. Since the money is going to the island for damages, does this mean that Dundee monies are for Ganabigondji for damages? No. So it does not mean that, this, and so let me be clear. The $45 million is for the community benefit as a whole. It's not for Cornwall Island benefits, not for Ganadigo, and it's not for Akwesasne benefits, the community as a whole. So if we receive this, doesn't mean that Cornwall Island will not receive any of the Dundee's money. So and that's Cheyenne says the money that was from the Seaway Dundee claims have not been allocated to any district. So after transfer of the process, council will decide what to do with them. So again, as I said in my opening comments with relation to the Dundee settlement, we have a process underway right now where we're consulting with the community. Yes, it has been a few years since the settlement happened. COVID has set us back. I know people are tired of hearing about COVID and the impacts, but 2 years we were not able to engage with the community on regular business activities. And had that not happened, we would have all of the mechanisms in place already for the Dundee settlement, implemented and benefiting the community. And that, that's not something that I can tell you as leadership we're happy with, but it's just the reality as it is right now. And I can tell you that we have the Aboriginal Rights and Research is doing a lot of work in supporting that. We had a claims coordinator who was engaging with the community on that as well. So there's a lot of work happening in the background with respect to the Dundee funds and making sure that the community has its say in how those proceeds are being used. So we're at 12:52. I don't see any other questions that we have. Was there anything, Cheyenne or Nathan, that you think we needed to mention in this afternoon's session that we didn't talk about or touch on?
I'll just jump in for a moment there. I have taken phone calls from community members who have specific questions, and that's fine with me. I answer them with complete transparency. I'm very frank with the community members. So this is your process. So you can send that to me, or you can send questions to Cheyenne, who will forward them to me. I'm traveling at the moment, but I will be back next week, and then I'll also be back in the community for another information session on the 23rd. Hopefully, I got that right, and that'll be on on the American side. So look up the venue on the website, and if you have questions or you want to go into more depth, meet me at that information session, or get in touch with me personally. I'm a bit limited what I can do on this situation, but if you want to go through particular pieces of the settlement agreement, or you have specific issues, don't hesitate to reach out to me.
Thank you. Brian?
So the meeting on August 23rd is at the Office for the Aging, Next Generations Park. I'd just like to point out that we do take down everybody's questions, and then we do have the answers. We write down the answers for you as Nathan answers them. So we have the most frequently asked questions that will be going on to Didawatalo today. It is being recorded and will be aired 4 times, I believe, prior to the start of voting. So if there are any other questions, feel free to send me them and I can get you the answers. And if I don't know the answer, I will be sure to make sure I get the answer for you.
Thank you very much for that. So just a reminder, we are having another in-person session next week, August 23rd at the Saint Mohawk Tribe Center at 6 p.m. We are hosting our virtual session today. If there are questions that community has or wants to have one-on-one with Nathan or Cheyenne or myself, please feel free to reach out. So the referendum is underway now online. We do have the in-person voting that is occurring on August 26th. The online voting has started on August 11th. Will go to August 25th at 5 p.m. If you had voted previously in the Dundee settlement, you'll recall that we use Simply Voting. So frankly, if you Google Akwesasne Simply Voting, that website will come up. It asks for your information, your date of birth, your band number, and then you're logged in. And you'll also see your previous ballot in there from the Dundee settlement as well. So that's the online voting that's occurring right now. If you need any technical questions or you have questions about that, please contact the Chief Electoral Officer, Leona Benedict, about the online voting or any questions in relation to that. We do once again have the in-person voting will be taking place on Saturday, August 26th from 9 a.m. to 5 p.m. at the Gawanoga District Recreation Center, Steiner Recreation Center, Ganadigo School, and at the St. Regis Mohawk Tribes Office for the Aging. So that is the in-person polling that will be taking place. So with that, I think we're going to bring it to a close. I want to thank everybody.
We have one more question that popped up in the
Yep.
chat, on the Zoom
Okay.
chat. I think we have time to answer that real quick, if you
Yeah,
want to.
okay, yes, absolutely. In addition to the potential settlement, has the government paid for any damages so far or paid for shoreline repairs? So that's a good question. About 25 years ago, there was what they called some remediation work that was done on shoreline protection through the entire area, not only in our community, but other parts of the community. They paid for that at that time. I can tell you that as an island resident and, you know, as a boater as well, there's lots of other areas that you know, either weren't fixed at that time because they only focused on the shipping channel. Or there are some places that have been stabilized. So they've paid for that. Is there any other damages? Nathan, I don't think that there's been any thus far, has there?
No, I think the one that really sprang to mind was the work that was done on shoreline protection by Canada, basically in the 1990s, and they did some really good work, but they certainly didn't do all the work that would have been required. So that is where they ended up in the 1990s. They stabilized the number of shorelines of a number of islands.
Okay, thank you. Okay, well, thank you so very much for joining us this afternoon. Thank you to the Aboriginal Rights and Research staff that's been working very hard on that, with Cheyenne and Cactus Cook has also been leading the way at the program there. Nathan Richards, our legal counsel, who's joining us today, has attended 3 sessions with the community, who is joining us today, will be there next week at the session at the St. Regis Mohawk Tribe Senior Center. But on behalf of myself, I want to thank all of you for participating, listening in on our Zoom live Facebook session today here at the Mohawk Council, talking about the Seaway claim, providing background on what the claim is about, and sharing information about the referendum that is ongoing now and then leading to an in-person voting taking place on August 26th, where you'll be able to cast your paper ballot. So with that, I thank you. All of you have a great afternoon. I appreciate you joining us, and we'll talk very soon. So, go.
Bona.